Good afternoon, everyone. I'm Judge Kulkarni. I am a judge in Santa Clara County, and I'm here today at the kind invitation of the Law Library to talk about law in motion. It's a fancy term for just filing motions. So we're going to talk a little bit about what it means, what the procedural requirements are, how you contest tentative rulings, how you should argue at the hearing if you get a chance to do that. And then we'll briefly touch on some other things. Just for a way of background, I've been a judge for about 12 years and have spent half of that time in doing civil cases, trials, law in motion, and complex civil. I currently have a temporary appellate assignment. Before I became a judge, I spent um, about 15 years or so at a big law firm in Silicon Valley, and then for the University of California in their in-house counsel's office. So I've seen a lot of different kinds of civil litigation, ranging from small cases to big cases. And so I think I can talk about how those things might vary. The other thing is that as a judge, I've seen big firms argue and provide papers. I've seen small firms or solo practitioners do it. I've also seen self-represented litigants do it. And all of them can do it effectively as long as they follow the rules. And we'll talk about that in a second. So we're going to talk about what law in motion is, some of the procedural requirements, especially with regard to summary judgment motions. Things have changed as of January of this year. We'll talk about the process of tentative rulings. They vary from county to county. Alameda is slightly different than Alameda, but the general overview is about the same. And then if we have time, we'll talk briefly about ex parte applications, TROs and preliminary injunctions, and writs of mandate. So key resources that you should follow, and that certainly the judges and the research attorneys follow, are the California Practice Guide from the Rudder Group and the California Judges Bench Book. Both of these things, I think, are available at the law library. Some of them are available through online commercial resources such as Westlaw and Nexus. And those are invaluable things to look at just to get a sense of the procedural aspects of the law. Because often these motions live and fall based on procedure, not the merits, but procedure. And so getting the procedure right is very important for making your motion work or defending against a motion from the other side. I'm not sure exactly what this picture means. I think it has to do with a bird getting ready to poop because sometimes judges, sadly, get a lot of briefs that are not so good. And so one thing that judges will often do is use procedural requirements to screen out cases that perhaps are unmeritorious or are going to take a lot of work. And so if you can follow those rules, the less likely it is the judge will screen your case out and will have to actually grapple with the merits of what you want the judge to do. All right. So what is law in motion? There's this fancy definition in the California Rules of Court, but it's basically most pretrial proceedings where you're asking the court to do something, where you're applying to the court or making an application before trial for an order for something. And it could be lots of things. It could be to compel arbitration. It could be to enforce a judgment. It could be to set aside a previous judgment. It could be more traditionally a whole bunch of motions, which we'll talk about in a second. All of these examples, these are more common. Motions to quash service, motions for leave to amend a complaint, a demur, a way to knock out complaints even before trial, anti-SLAPP motions, motion for summary judgment. There are lots of different kinds of motions that come under this rubric of law in motion. And depending on which county you're in, they're handled a little bit differently. Some counties, there'll be civil judges who handle a case from beginning to end, and they'll hear all your motions. Other places have a setup, for example, like in Santa Clara County, where you have a case management judge for regular cases who hears all these motions, but someone else hears the trial. But even there, for complex civil cases, we have two judges who do complex cases, and they hear all of these motions. In some places, injunctions and TROs are handled separately. In some places, petitions for writ of mandate are handled separately. So it really is a county by county thing. And so it's really important to figure out what the local procedures of your county are. Some more motions, perhaps not quite as common, but certainly motions that courts see all the time. Discovery motions are a big one. If the other side is not being cooperative in discovery, you need to file a motion. Your law and motion judge, your case management judge, your all-purpose trial judge will hear those kinds of motions. And like I said, local rules and practice make a big difference in terms of where things are heard. For example, if you want to continue a trial, in some places those go to the case management judge. Some places they go to the all-purpose judge. In some places they go to the supervising judge of civil, who then assigns out trials. And so again, you want to find out, based on local rules and practice, where motions are filed. And judges vary. Some judges are very active in managing civil cases, and they take a great interest in trying to push the case along. Some judges are more passive and say, look, this is the party's case, and if they want to file motions and not move the case along quickly, that's their prerogative. Some judges are very much a stickler for rules. If you violate the rules in some way, we're not going to hear your motion. Maybe you can try again later, but I'm not going to hear your motion right now. Versus some judges say, not a big deal. They missed the deadline by a day. There was no harm to anybody, no prejudice. And so we'll go forward. You probably won't know what kind of judge you have before you get that judge. But again, it's important if you can follow the rules to do so. And if you can't, provide a good explanation why you didn't follow the rules. You don't want to take a chance that a judge is going to bounce your filing because you violated the rules. So there are special rules for certain kinds of motions. Demurs, again, in the federal system, we call 12b6 motions. But basically motions that say, even if you agree or even if you assume everything in a complaint is true, it still fails. Motions to strike, how to amend pleadings, if you want to find a change of venue, discovery motions. There are special rules for all of these. In some ways, the most important rules in my mind that are special are summary judgment. There's a whole set of summary judgment rules and the statute, which has been amended relatively recently, which you need to follow. Often a summary judgment motion is the only thing between you and trial, whether you're a plaintiff or a defendant. And so it's really important to get those rules right so as to not to give the judge a reason just to disregard your filing without considering the merits. So again, a lot of this stuff is kind of boring. It's not very exciting, but it's something that judges expect, and especially if you're a self-represented litigant, making your papers look like regular filed papers like attorneys file is important. I think judges probably take it more seriously when you follow the rules. And so you need to have a notice of hearing, a motion, and a memorandum. A motion is different than a memorandum. The motion briefly summarizes the relief you seek. The memorandum gives the how and the why. It's the brief, but you need to have a motion and a notice of hearing. There are often declarations or affidavits that accompany your motion, maybe a request for judicial notice, some exhibits if documents are important. There are page limits, and this is really important, especially for self-represented litigants. I know there are a few on this call. 15 pages for a regular motion and opposition and 10 pages for a reply It's really important to follow that. If you don't, again, some judges are going to say, I'm not going to read your 58-page opposition or your 70-page motion or reply. They just won't. And then you will just lose a chance for relief. So following the rules is very important. You get more pages for summary judgment, but even then, I've seen not just self-represented litigants, but often attorneys just blow through those limits without asking for permission. And then they're surprised. The judge says, look, I don't have time to read your 50-page brief. It doesn't follow the rules. I've got 15 other cases I need to decide today. You need to follow the rules. Try again. And so the more you can comply with the rules up front, the better off you'll be. If you really think you need to file a longer brief, ask for permission. It's likely a judge will grant it within reason. But if you don't ask for permission, it can be a problem. So, summary judgment. There's a very stylized way that a summary judgment motion is filed. Not just the notice of motion and the memorandum, but also you need a separate statement of undisputed facts. And there are rules on how that's done, and these code sections and rules explain that. And the next point is very important, that if you don't file a separate response to a separate statement, that can by itself justify granting the motion. So even if you have super meritorious arguments about why you should get to trial and why a jury should decide all these factual disputes, if you don't follow these rules, you may lose. And the case will be decided against on summary judgment. So it's very important to follow these rules, to understand how they work, and to not give a judge an excuse not to read your papers. I mean, judges are busy. We're busy. And it's often a ton of work if people file tons of documents and tons of briefs. And this may be a shortcut for either the judge or the research attorney not to consider papers, and you don't want to give them that shortcut. Similarly, with regard to discovery motions, the rules generally require that you file a separate statement where you go through each of the issues and each of the documents you may be requesting, or each of the discovery requests that weren't responded to properly, and explaining each one. Some judges don't require you to do that, but you need to find that out first. Or at a case management conference, ask the judge, look, judge, we may need to file a discovery motion. Do you need a separate statement? Some judges say, sure, I don't need one. I'm in that camp, but you got to ask me first. All right. There are these things, judicial counsel forms. You can find them on the Judicial Council website, courts.ca.gov, I believe. And you can find these forms, and they're mandatory for certain kinds of things. For example, if you want to dismiss a case, if you want to stay proceedings, if you want an order of examination, and you need to follow those forms. Again, does everybody use them? No. Will a judge or a clerk's office probably not get mad at you? Probably, but you don't want to take that chance. It is certainly better for you to use the forms when they're mandatory, and even consider looking for them even if they're not mandatory, because if you follow the forms, you're unlikely to have any issues procedurally. So really look for forms that might apply in your situation and use those forms. Again, you want to give the clerk's office, and especially the judge, no excuse not to consider the merits of your case. So notice, you got to make sure the other side knows that you're going to file a motion, and you need to give them time. So if you're filing the motion, if it's not a summary judgment motion, typically, generally, at least 16 court days notice. Often you might file more, plus actual service. opposition 9 court days, and reply 5 court days. So it is always a bad idea for any substantive motion, certainly, and for motions in general, to file a reply the day before the hearing. And this is true for attorneys and non-attorneys alike. A judge is not going to be very happy with you. And if it's something where they have a research attorney helping them, the research attorney will not have had a chance to incorporate that reply into a draft opinion or the analysis. And again, it's a reason that the other side can stand up and say, Judge, they didn't follow the rules. It's not fair. Don't consider their opposition or don't consider their late reply. And so again, you don't want to give anybody an excuse to do that. So make sure to give plenty of notice. Summary judgment. This is new as of January 1st, 2025. 81 calendar days notice plus service. 20 calendar days for an opposition. Reply 11 calendar days. And so it's really stretched out. It used to be 75 and now it's 81. So if you want to file a summary judgment motion, you need to really think way far in advance. And if you're on the other side and the defendant is filed a summary judgment motion, let's say 45 days before trial, you should jump up and down and say that's not allowed. The timing doesn't work. The motion itself has to be heard at least 30 days before trial. So if you're on the other side, try to enforce these procedural requirements. But the point is, if you're opposing or if you're trying to move for summary judgment, recognize that you need to file something generally at least 4 months before trial. So this is often an issue in terms of counting the days, figuring out when things are due. When it says 5 court days for a reply, how do you figure that out? Well, it talks about counting backwards. And sometimes you have to count forward from a certain event. You want to make sure you take holidays into account. And so the safest thing you can do is make sure to file a little bit early if you can. So you don't have to worry about exactly how to count things. Meet and confer. So first of all, what's meeting and conferring? It's really talking to the other side and saying, look, I think there's an issue with your complaint. I think your second cause of action for defamation or slander doesn't work legally, and here's why. Or I think that your third cause of action, breach of contract, doesn't plead any facts. And so you got to fix it because it just doesn't work. We don't know we don't know what you're saying. And try to have that conversation orally. What I hate, and I think lots of judges hate, is just letter writing campaigns back and forth, where I write a letter setting forth my position, you write a letter setting forth your position. There's no meaning conferring. It's just a regurgitation of the arguments you're going to have in your briefs. No one's thinking about trying to compromise, which is why the CCP, the Code of Civil Procedure, talks about how this meeting confer needs to be done in person, by phone, by Zoom, and explain in the declaration exactly how that happened. And so really try to meet and confer. Sometimes it's not pleasant to do that, to actually have a conversation with someone you hate or someone who's on the other side who's unreasonable. But you got to at least try. And judges really want to enforce this. And so they might take your motion off calendar until you can prove that there was meet and confer. Maybe they'll kick out the hearing for a couple of months so you can have that meet and confer. Maybe they'll order you to meet and confer in person. I've had situations where I've asked people to meet and confer in the courthouse itself because they couldn't get along. But what judges can't do is rule against the moving party just because they didn't meet and confer. That hammer is too much. But sometimes taking a motion off calendar or delaying it for 2 months is a big deal. It just causes delays for everybody. And so again, try to meet and confer when you can. I definitely see a lot of self-represented litigants not follow this rule that a meet and confer has to happen. And if you're the self-represented litigant, you're the plaintiff, if the defendant tries to meet and confer, you need to try to, accommodate them and do that meet and confer. You can't just avoid them. Late filings. Again, first of all, try not to file things late. Second, I get we're all busy. Sometimes things slip through the cracks. Personal things come up. It happens. And so courts vary in how they handle these things. Some courts won't consider late filed paper at all. Then they have to say so. A lot of courts will say, well, did it prejudice the opponent? Did anything in the reply brief, for example, say anything so new and so earth-shaking the opponent needs a chance to respond? Not just orally, but in writing. If so, consider the late reply, but allow the other side to file a surreply and kick out the hearing for a month. And so there's discretion, but you don't know what kind of judge you're going to get. You don't know how cranky the judge is going to be. And so if you have to file something late and you didn't get permission, say, look, judge, I'm really sorry I filed this late. I'm sorry I filed, my late opposition. If the other side needs a little more time, I'm happy to give it to them. Let's postpone the hearing for a month. You see it seem much more reasonable than if you say, I was just a day late. Who cares? No one cares. Let's just go forward. It's not the best way to ingratiate yourself with the judge. So one thing that often causes problems is for the moving party to bring in new evidence on reply. Because the whole point is that if you do on reply, the other side doesn't get a chance to respond. If you do in the opening papers, the other side can respond in the opposition. And so you generally don't want to bring in new evidence. And now there's a new rule, or the statute for summary judgment specifically says that. And this often applies not just to new evidence, but also to new arguments. It's not fair to make a new argument completely out of whole cloth or whatever it is in reply, and the other side doesn't get a chance to respond. If that argument is so important, you should have made it earlier. And so really try not to do that. Or if you do it, negotiate the other side so they can get a chance for a surreply. It's just something that just doesn't make judges happy. All right. So here's an example of how these procedural things might come about. We've got a bench trial and at the final kind of pretrial conference for trial, it looks like all the issues left are just legal issues. There are no facts. And so let's just do a motion for summary judgment. But there are only 10 days between the trial date and this conference. There's no time to file a summary judgment motion. Remember, we need 30 days to do that. Is what the judge did here okay? Shortening time, having quick briefing, and granting judgment. Was this okay? No. Even if you can shorten the time by which a motion should be heard, you can't do it in terms of the notice period. And now we have this really lengthy notice period. And so this is another reminder that if you think a summary judgment motion is a good idea, think about it and file it way earlier. Don't wait till the last second to raise that issue. Or at a minimum, meet and confer with the other side and see if they agree. Maybe it saves people lots and lots of money on both sides not to have a real trial. But don't do it like this. So defendants move for summary judgment, 76 days notice. Actually, 5 less than required, not 4. And they set the motion for hearing 18 days before trial. Plaintiffs say, hey, that's not fair. That's not following the rules. The trial court tries to split the difference, gives a little more time, and says, defendants, you want to have this trial, you want to have this motion heard just before trial? Explain why. It then grants this motion. Is this okay? No. The 76 days was not proper. It violates the law. The trial court has no authority to continue the hearing or to do anything else. And so, even though it's only 4 days or 5 days, it's a violation of due process. It violates the law, and it can't happen. Again, it would be different if everybody agreed. If everybody said, sure, I don't care about the 4 days, everybody's fine with it. That's different. But if the other side is objecting to it, it doesn't work. So again, don't cut it so close. Think about filing it instead of 4 months before trial, 6 months before trial. After all, the earlier you file it, the less trial prep and trial money you'll have to spend. So don't try to take these chances by filing it right on the cusp and then try to engage in these kind of shenanigans to make sure the judge can hear it, because often it doesn't work. All right, tentative rulings. There are lots of different ways that courts can give tentative rulings. I think now a common way, this is a way that we do it here in Santa Clara County, it's done in other bigger counties as well, is that the tentatives are available online or by phone the afternoon before the hearing. The whole point of it is you see the tentative ruling and the losing party can decide, I kind of see where the judge is coming from. It's not worth trying to change his or her mind. I'm not going to contest. And that just saves time for everybody and money. Or if you think, oh, the judge got it wrong and you contest the tentative ruling, at least there's something for you to shoot at. You know, judge, you said A and B. I agree with A, but I think B, with respect, is not correct, and here's why. It allows you to focus your arguments in. When judges post tentatives, there are lots of different ways to do it. One way is to say, I don't know, let's just have a hearing. I've done that sometimes when I'm really not sure what the right answer is. Sometimes judges, and I've done this too, saying, I'm not sure about these particular issues. I want you to be ready to focus on these particular legal issues or factual issues, so you don't have to spend your time preparing for other stuff. The tentative may be a full opinion where it explains exactly what's going on, why one side should win, why one side should lose, whether the motion is granted or denied. Maybe you get leave to amend the complaint if it's a demur. Maybe it's without leave and the case is over. Some judges put a lot of detail in the tentative and then just use that tentative as the final ruling. Some judges put a little bit of detail and then beef it up when they file a formal order afterwards. It really depends judge by judge. And I think each county has its own culture on this. And so these are some potential issues, but I realize that what you think we should talk about is when you see the tentative, you have an obligation to respond quickly to let the court know whether you're going to be contesting or not. And this is for the losing party. And you need to let the other side know. It's really annoying for a law and motion judge to have somebody come to court saying, Judge, I'm contesting your tentative. The other side's not there. Where's the other side? I don't know. Well, did you tell the other side that you were contesting? Well, no. Well, then now we really can't go forward. The other side has a right to respond to your arguments. So let's just continue this for a month or 2 months. So we'll allow you to have a chance. So make sure it's super important, not just that you tell the court you're going to contest, but you tell the other side you're going to contest. So everyone's ready to come. So at the hearing, if you need an ADA accommodation, talk to the ADA coordinator at the court. it may be that judges want to kind of clear out things first, and so they'll just call things where no one's contesting, and then call contested matters at the end, even if your matter is listed number 1 on the calendar. So be ready for that. Telephonic appearances are generally okay. In a lot of courts now, Zoom appearances or Teams appearances are okay. Certainly after COVID, that's been happening a lot more. If you're self-represented, again, you got to follow these rules. I mean, judges may give you a little bit of slack, but if you're a self-represented litigant and you don't like a tentative ruling by a judge, you need to make sure that you let the other side know that you're going to appear and that you're going to contest, and you let the judge know or the court know you're going to contest. So they're ready too. You generally can't have live evidence at a hearing. And then after the hearing, typically there's a written order afterwards. Sometimes the court will take the matter into submission. Sometimes the court will just note in the minute order, tentative ruling adopted, prevailing party prepare an order. And so there'll be an order prepared reflecting what was said in the tentative. And so you want to be thinking about all these issues when you're at the hearing and before you leave the hearing. And remember, your time at the hearing is not going to be that long. And so you want to be ready to talk, but just keep in mind, a typical law in motion calendar may have 10 to 15 matters. To get through that in 3 hours, especially when some require some significant argument, is hard for a judge. And so you need to realize you won't have all day. Even if this is your big case as a self-represented litigant, it's unlikely a judge will give you an hour or even sometimes half an hour. So you want to be ready to really talk about the points you have crisply and succinctly. All right, so here's an example where people did not follow the rules about notifications. So the plaintiff credit card company in this collection case filed a motion to compel discovery against the defendant. You're the judge, you post a tentative granting the motion in favor of the credit card company. But the defendant just shows up in court. They didn't tell anybody they wanted to oppose the tentative. They didn't tell the court. They didn't tell counsel. They just appear and they won't argue. What happens? Well, there are a few options. I don't have a slide for this, but I'll just talk through it. There are a few options. Some judges might say, look, you did not tell the other side and you did not tell the court you were contesting. You're bound by this. You lose. Some judges might say, look, I know you're self-represented, but you got to follow the rules. I'm going to give you a pass this time. We'll come back in 2 weeks, and at that time you can argue. That's probably what I would do. Some judges would say, okay, look, I know you didn't do what you were supposed to do, but we've got everybody here now because sometimes the credit card company is here. Credit card company lawyer, can you argue anyway? They'll often say yes, and you just argue. And so lots of approaches, but again, the safest thing to do is just follow the rules. We talked about ADA accommodations. All courts have to have an ADA a coordinator. And so you want to make sure that if you have a disability or you need an accommodation, whether it's a cart reporter, whether it's being able to use your phone as a recording device, or whatever it may be, you need to ask for it. But depending on the kind of accommodation you need, if it affects the other side may get a chance to look at your medical records and have an in-camera hearing and decide whether the accommodation that we're talking about is appropriate. It's often called a VESCO hearing after this VESCO case. And so you want to be ready to recognize that if you're asking for some kind of significant accommodation, look, judge, I have a learning disability. I can't file motions on the usual schedule. Can I get twice as long to file a motion and twice as long to oppose? You may need a VESCO hearing because it might prejudice the other side. And both sides talk in camera where no one's there, and the judge will decide whether that's okay. but just be aware that that kind of thing may happen. So in terms of oral argument, you want to prepare and practice. You want to know the record. You want to know what the facts are and what documents relate to those facts. And you want to make sure you tell the judge who you represent, whether you're self-represented or not. Describe the motion. But the key is do it briefly. Focus on your most persuasive point. But if the judge asks questions on a thing, go there. Make sure to answer the judge's questions. Don't avoid, exaggerate, or misstate. The lots of pet peeves for judges, one of them is if you ask a question and the person, whether it's an attorney or non-attorney, doesn't answer the question, but talks all around the question and doesn't answer the simple question, if it is simple, yes or no. It just annoys people and doesn't help you. And be concise. You're not going to have that much time. Maybe you'll have a total between the two of you in a particular matter, 15 minutes or less. Just given the time constraints. And so you really want to focus on your most persuasive point. That relates to the motion. This is not a chance to argue your entire case. That is not helpful to anybody. The judge has a job to do, which is decide this motion, focus on facts that relate to that motion. Focus on law that relates to that motion. So written orders. For simple motions, I would say probably most judges ask the prevailing party to prepare an order. Sometimes you'll say, I'll prepare the order because it has a lot of reasoning and I want to make sure I get it right. Judges don't have to make specific findings most of the time. There are some exceptions listed here. There may be some others. But often it's enough for a judge to say, motion for application to file a late brief denied. No good cause shown. It's not the most descriptive necessarily, but it's not improper. And so when you go on appeal, it's not a good ground for objection to say, well, there wasn't any detail. On appeal, the appellate court will assume there are facts to support that conclusion. And so you don't necessarily need findings to be explicitly made. Places where reasons should be provided is when you are knocking out a case on demur, sustaining the demur. When you're granting or denying summary judgment, you want to give reasons. There's some other ones too. Those are probably the two biggest ones. And for those, typically, the judge will make their own order. Not always, but typically. And so you really want to be paying attention at the hearing to see what the judge's preference is. All right, so here's a hypothetical about oral argument. Defense move for summary judgment. Plaintiff opposes. So far, so good. Kind of natural. Everybody objects to everybody's submissions. And the judge says, I don't want to hear oral argument. I'm deciding the motion. I'm denying the motion. Here's my lengthy written order. Is this okay? And the answer is no. That's different than the federal system. In the federal system, often trial court judges, district court judges, can decide things without oral argument. But in the state system, generally oral argument is required, or at least an opportunity for it. Again, you can waive it or forfeit it if after a tentative ruling you don't respond in time. But generally, you have a right to be heard at a summary judgment hearing. It promotes the interest of fairness. You might say something at the oral argument that may change a judge's mind. And so most judges know this. Most judges know that everybody should get a chance to be heard. But you'll only remind judges if they forget. Okay. We have about 10 or so minutes left. because I don't want to keep you past 1 o'clock. So we're briefly going to talk about a few other kind of specific areas. One, ex parte applications. It's an emergency. You desperately need to get some kind of relief, and so you'll find this ex parte application. And so in your ex parte application, you need to show irreparable harm, immediate danger, or some other reason to get relief ex parte. And the whole point of an ex parte application, you're getting it fast and maybe even without notice the other side. Although in reality, notice the other side usually happens. And so when I think of ex parte applications, most of the time I think of them as being regular motions on really condensed, quick schedules. There are requirements, and judges often enforce these pretty strictly. You're asking a judge to go outside his or her comfort zone and make decisions really, really quickly. And if you're going to do that, you got to follow all the rules. And if you don't, an easy way not to decide it for a judge. So here are some common examples of ex parte applications. Some of them aren't emergencies. It's just that the law permits you to use the ex parte application process. If you want an extension of time to answer, I'm not sure it's an emergency, but you can use it this way. But for example, if you want to stop the deposition of, let's say, the corporate CEO because you're appealing some order or seeking a writ to a higher court, if you want to stop someone from taking money out of a bank account, if you want to make sure you get more discovery before the summary judgment motion is heard, those are more emergency kinds of things. And those are where ex parte applications make sense. But as I said, typically in the context of ex parte applications, the judge won't rule without hearing from the other side. They'll just make the other side file a response or give an oral response that day or maybe the next day, and the thing gets decided very, very quickly. It's typically not the case the other side doesn't get to respond at all before relief is made. All right, so temporary restraining orders, TROs, and preliminary injunctions. Again, a temporary restraining order, you need irreparable harm. You want to stop something from happening even before you have a full-blown trial. And so again, the rules you have to follow, you have to file declarations saying, I want to restrain this party from holding a vote to kick out the officers of a corporation. I want to stop this employee from working for my competitor. Or that kind of thing. Again, most of these TROs aren't truly ex parte. Rather, it just forces the judge to say, look, the other side, respond today. And you decide quickly. Again, just like with the TRO, which is like an ex parte application, TRO has rules. There's a whole process on how preliminary injunctions flow out of TROs. I'm not going to go through all of that, but that's certainly a great place to look at the Rudder Group Guide, which I talked about at the beginning. They go through all the details in terms of how the preliminary injunction process works after a TRO. The two-factor test for granting a TRO or preliminary injunction. You have a reasonable probability of winning on the merits, and you weigh the equities. You look at the interim harm the plaintiff might sustain if you didn't have an injunction versus the interim harm the defendant might sustain if the injunction were issued, kind of weigh that as a judge, and then go from there. And so you really want to make a good factual showing that A, you're going to win on the merits, but B, sometimes even more importantly, that if you don't get an injunction, the sky will truly fall and the defendant won't matter. And if you're on the other side of it, vice versa. So that kind of factual showing goes a long way, especially for a judge who doesn't know anything about the case, anything about the facts, because you're doing it on such short notice. And the whole point of a preliminary injunction, or before that a TRO, is to preserve the status quo until we finally have a trial, until we finally decide once and for all who's right and who's wrong. And so when you're thinking about this, sometimes public policy comes in. And if you're seeking injunctive relief, it always comes in. And so, for example, if you are a homeowner and you're trying to stop the city from tearing down your house because it's a nuisance, you want to talk about public policy. You want to talk about the huge harm you'll suffer from this versus the minor harm the city might suffer by not knocking your house down. And you need to make the significant showing of irreparable injury. And then finally, writs of mandate. The Law and Motion Department may hear these kinds of motions. Excuse me, in some places, for example, in Los Angeles, they have a whole separate department, writs and receivers, that hears these kinds of motions. And the idea is that you're asking a state agency or the state to do something. For example, if you are a doctor and the Medical Board of California isn't renewing your license or is disciplining you for something, you can seek a writ of administrative mandate to say, look, what the agency did was wrong, and we're going to fight it. A writ of regular mandate is an attack on kind of an ongoing policy that an agency may have. For example, if the DMV always takes away the license of someone who has been charged, not convicted, but charged with a DUI, you could attack that policy through writ of mandate. But if there's a specific decision that's made by some kind of quasi-adjudicative board within an agency, you attack that through administrative mandate. And there are lots of specialized rules for that, but that's a form of law and motion as well. All right, so I just want to wrap up with a couple of points. The first is follow the rules, follow the rules, follow the rules. Again, because the rules are good, and even if they seem kind of dumb, it's still what judges expect. You want the judge to consider your arguments on the merits. And the best way to do that is to follow the rules. Conversely, if you think the other side hasn't followed procedural mandates, tell the judge. Again, it's an easy way for the judge to not have to get into the nitty-gritty of deciding the merits. But if you are the plaintiff and you want the judge to decide these merits, or you want to get to a jury, make sure to follow the rules. Second, be brief. A 40-page brief is not 4 times better than a 10-page brief. In fact, it's probably 2 times worse. The more concise you can be, the more likely it is you'll win. And this is especially true for self-represented litigants. Try to follow the page limits and get your arguments succinctly so that a court can understand them. So I would say those are the two key things. Follow the rules and be concise. And if you do those things, you'll go a long way towards getting a judge to be on your side and eventually having a jury on your side as well.
First of all, thank you very much. This has been very helpful. I am one of those pro per people. My question is, tentative ruling is issued. The party loses. The attorney then wants to contest. They show up in court on the day the tentative ruling is heard, and they fail to give notice. They didn't notify the other party, the defense. This is the attorney representing the plaintiff. They didn't notify the defense, and they didn't tell the court. In this case, the attorney said they didn't know they were supposed to notify the court that they were going to show up. Am I understanding correctly from what I learned today, that every county is different, that in some courts you don't have to notify the court that you plan to show up?
No, no, no. If I said that, then I probably didn't say it properly. What I meant to say, you have an obligation if you're going to contest the ruling to notify. How the notification occurs can vary by county, and the timing can vary by county, but it's undisputed, and the rules require you have to notify the court in some way, and typically the local rules say how to do that, but you have to notify the court.
Okay.
Second, you have to notify the other side.
Yeah.
That's non-negotiable. And
Right.
if those things don't happen and there's an order entered against you, you can move to set it aside by saying, look, I didn't even know there was this order because they didn't give me any notice. So, but yes, there's an obligation always to notify.
Okay. Thank you very much. That makes sense, and that's what I thought. Thank you.
I have a question.
Okay?
My question is, because the court, oh, by the way, great presentation. The court, since the court is short-staffed and sometimes they don't follow the court calendar, is that acceptable?
When
Yes.
you say they don't follow the court calendar, what do you mean?
They postponed say I had a court date on the 10th, and they sent a letter saying that they postponing the court calendar.
Yes, I would say yes. Sometimes the court will, on its own accord, say, look, I've got too many motions on the 10th. We're going to postpone your motion to the 17th or the 24th. That is okay, as long as the court doing it. The other side can't do it unilaterally, but the court can do it, and it happens sometimes. All right, I see a few questions in the chat. Let me just answer some of them before we break. One of the questions was, can you let the judge know the other side didn't follow the rules after the fact? And the answer is yes. If you think the other side got a ruling in their favor, you can appeal and explain what happened. You could move to set aside a judgment that you think was gotten improperly and explain how the rules were violated. So that's okay. Second, there's another question about how to get permission to file a brief that's longer than the page limit. Probably the easiest thing to do is try to see if the other side will agree to it, and then you file a stipulation saying both sides get 30 pages for their opening briefs and oppositions and 15 pages for their reply. If not, you just file a motion directly with the court. And then finally, I'll do one last one. On a motion to set aside by defense counsel, a demur was filed. And should the plaintiff file an objection to the motion and respond to the demur? Certainly, the plaintiff should oppose the motion to set aside. In terms of responding to the demur, that's a little more complicated, because if you respond to the demur, you may have waived any jurisdictional issues. But if you're the plaintiff, it's probably not an issue, so you probably should respond to both. All right. Thank you so much, everyone. I appreciate everyone being here and asking questions, and I hope everyone has a great afternoon.